joined another party or sought to be treated as an independent raises serious concerns about disregarding the trust reposed in him or her by the voters, thus undermining the will of the people. And number 4, the legal implications, effects, consequences of the determination made above in paragraph 2.2 and 2.3, as well as the actions or inactions of Election Commission of Pakistan thereon, although deeply concerning, have not been challenged in the present appeals and petitions, and the persons who would be affected or aggrieved are not parties before this court. Therefore, issuing a definite direction to the Election Commission qua the allocation of specified number of reserved seats for women and non-Muslims to a political party in the National Assembly and the Provincial Assembly would not be legally appropriate. Accordingly, the Election Commission of Pakistan is directed to decide the allocation of reserved seats for women and non-Muslims to political parties in the National Assembly and the Provincial Assembly in the light of the determinations made herein above, after providing opportunity of hearing to the parties concerned, and if required, revisit its earlier decisions on the matter. The needful be done within 7 days of receipt of this order.
Majority order. And I repeat, it is by myself, Justice Munib Akhtar, Muhammad Ali Mazhar, Aisha Malik, Atar Minallah, Sayyid Hassan Ali Rizvi, Shahid Waheed, and Irfan Sadat Khan. For detailed reasons to be recorded later and subject to what is set out therein by way of amplification or explanation or otherwise, these appeals are decided in the following terms. Number 1. The impugned judgment dated 25th of March 24 of the learned full bench of the High Court is set aside to the extent it is or may be inconsistent with this order or the detailed reasons. Number 2. The order of the Election Commission of Pakistan dated 1st of March 2024 is declared to be ultra vires the Constitution, without lawful authority and of no legal effect. 3. The notifications of various dates whereby the persons respectively mentioned therein, being the persons identified in the Commission's notification dated 13th of May 2024, have been declared to be returned candidates for reserved seats for women and minorities in the National and Provincial Assemblies, are declared to be ultra vires the Constitution, without lawful authority and of no legal effect, and are quashed from 6th of May 2024 onwards, being the date an interim order was made by the court in CPLA number 13289 of 24, the leave petitions out of which the instant appeals arise. 4. It is declared that the lack or denial of an election symbol does not in any manner affect the constitutional and legal rights of a political party to participate in an election, whether general or by, and to field candidates, and the Commission is under a constitutional duty to act and construe and apply all statutory provisions accordingly. Number 5. It is declared that for the purposes and within the meaning of paragraphs D and E of clause 6 of Article 51 and paragraph C of clause 3 of Article 106 of the Constitution, Pakistan Tehreek-e-Insaf, PTI, was and is a political party which secured or won the 2 terms being interchangeable general seats in the National and Provincial Assemblies in the general elections of 2024 as hereinafter provided. 6. During the course of the hearing of the instant appeals on 27th of June 2024, Learned Counsel for the Commission placed before the court a list of 80 returned candidates for the National Assembly, now MNAs, setting out in tabular form particulars relating to their election. Learned Counsel made a categorical statement that the Commission stood by the data so provided to the court. In particular, the list contained 3 columns marked as follows. Number 1, statement or nomination form given in declaration and oath by the person nominated, that is, I belong to. Number 2, certificate of party affiliation under section 66 of the Election Act 2017. And number 3, statutory declaration affidavit accompanying section 66 certificate. Number 7, in the peculiar facts and circumstances of the general election of 2024, it is declared that out of the aforesaid 80 returned candidates, now MNAs, those being 39 in all and whose particulars are set out in Annexure A to this order, in respect of whom the Commission has shown PTI in any one of the aforementioned columns in the list, were and are the returned candidates whose seats were and have been secured by the PTI within the meaning and for purposes of Para 5 above in relation to Article 51 provisions. Para 8. In the peculiar facts and circumstances of the general election of 2024, it is further ordered that any of the remaining 41 returned candidates out of the aforesaid 80, which is mentioned in the Annexure B, may within 15 working days of this order file a state.
इसी तरह हर तरह की लेटेस्ट अपडेट्स और ब्रेकिंग न्यूज़ के लिए वीडियो को लाइक कर दें, चैनल को सब्सक्राइब करके बेल के आइकॉन पर लाजमी क्लिक करें ताकि आप रहें हर खबर से बाखबर।